So your spouse says that they want an amicable divorce, and they present you with an original petition for divorce and a waiver of service. What is the waiver of service? And if you sign it, what exact rights are you giving up in signing it? That's the topic of today's video. Hi, my name is Sean Palmer with the Palmer Law Firm, and I've been practicing family law in the great state of Texas for the last 19 years, exclusively in the area of family law. And as part of the process of getting a divorce, the file of the original petition for divorce is the first step, but then the next step is the thing we call personal service. The person who is the respondent in the case must get notice that the case is going on. And service of process is covered under 6.4035 of Texas Family Code, and it details processes. And one of the things that you can do as part of that is to waive personal service. In other words, you can sign a piece of paper that says that a process server doesn't have to come and personally hand you papers. And with the waiver filed with the court, that's proof enough that you are on notice for the case. Now, I know a lot of attorneys don't like the idea of signing a waiver, but personally, I think a waiver can be a good idea if you really are moving forward on a friendly divorce. And it sets the tone for the rest of the case if you go ahead and sign the waiver. But you have to be very cautious before you just sign away your rights, because that's essentially what you're doing. I say that waivers come in many different flavors, and they range from mild to extra very hot. So you want to make sure that you read that waiver very carefully before you sign it and see exactly what it is that you're waiving. In most cases, it would be reasonable for someone to sign waiver of service for service of process only. But a waiver might be presented to you that has all other kinds of waiving of rights in it. So that's why you have to read very carefully. You could waive away your right to have a record made of the proceeding. That might not be a good idea if there's ever a need for an appeal. You might sign away your right to protest an associate judge hearing the case, and may decide that you wanted the case to be heard in front of the sitting judge. If you sign this waiver, you may be waiving that right. Also, you might waive notice of trial, so they could proceed all the way up to trial and not let you know what's going on, and your voice wouldn't be heard in court. Again, I would not recommend signing such a waiver unless you're really sure that's what you want to do. Another thing that they could say is that if you're in the military, you're waiving your Service Member Civil Relief Act rights, where you would be able to get any proceedings delayed because of your active military service. So if you're in the service, you want to carefully consider whether you're going to sign that right away. And waivers of service can go all the way up to an extreme version where you're waiving any right to know anything that's going on. You're waiving your right to notice of any hearings, and basically they can move forward and you won't have any notice of anything, and they'll proceed however they want, and they'll probably get anything they want, the opposition. So you got to be careful when you're signing a waiver, and make sure that a lot of those extra things aren't put in the waiver unless you very much intentionally want to give up those rights. When you get a waiver of any kind, you want to make sure that you're also reviewing the original petition. You can't file the waiver of service until after the original petition has been filed. So make sure that if you're getting a waiver of service, that you get an original petition that's been file stamped already, so that you know that that's the actual petition that was filed and not some other version. And after you sign the waiver, it has to be filed with the court before it's made official. So if you have any questions about whether or not to sign a waiver, it's probably a good idea to go ahead and get an attorney to review that before you go ahead and sign it. But if you want to sign it without getting an attorney, then just make sure that you're reading it very carefully. As with anything in law, you want to make sure you're reading everything prior to signing it, and make sure you understand everything in it before you do that. Otherwise, you might be irrevocably waiving rights that you otherwise would have. So be cautious. But also, if it looks good on its face and you want to try to get it an amicable divorce going, if you have it, and particularly if you have an attorney check it out beforehand, it might be okay to go ahead and sign the waiver, because what it does, it avoids the cost of personal service to have somebody, hire somebody to go out and serve you with the papers. If you can avoid that initial cost, so much the better. Well, that's what we have for today. My name is Sean Palmer with the Palmer Law Firm, where we can't protect your heart, but we can protect your rights. And if you have any questions about this subject, just leave a comment below. We'll try to get back to you, and I wish you the best of luck.